Hi everyone, my name is Anita Casavantes Bradford. I'm Assistant Professor of History and Chicano-Latino Studies at UC Irvine, and today I'll be talking to you about unaccompanied children and U.S. immigration policy. In this webinar, I'm going to talk about the historical relationship between U.S. immigration policy and the experiences of unaccompanied migrant children to the United States during the second half of the 20th century. So my interest in this topic stems from research that I did for my first book, The Revolution is for the Children, The Politics of Childhood in Havana and Miami, 1959 to 1962. And in this book, I talk about the way that children were involved in the politics that led to the radicalization of the Cuban Revolution, as well as to the creation of the Miami exile community in South Florida in the early 1960s. So one of the important moments in this political process was something that would later become known as Operation Pedro Pan, whereby approximately 14,000 Cuban children came to be cared for in foster care in the United States. Those children were sent to the United States by mostly middle-class Catholic Cuban parents who were afraid that their children would be exposed to communist indoctrination if they remained in Cuban schools. The more than 14,000 kids who came to the U.S. would ultimately be cared for by a federally funded and Catholic Church overseen program that was run by Monsignor Brian Walsh, an Irish immigrant priest in charge of Catholic charities for the Diocese of Miami. The U.S. government and intelligence community welcomed the opportunity to work with the Catholic Church in order to protect Cuban children from Marxist indoctrination. The U.S. government pledged federal funds to the Cuban Children's Program. And interestingly enough, the State Department also granted Father Walsh a blanket waiver to issue visas to Cuban children under the age of 16. This was a completely unprecedented move, granting discretionary power over immigration admissions processes to who was then a 30-year-old Catholic priest and himself a recently naturalized U.S. citizen. By the conclusion of this program, the federal government had infused more than $138 million in the Cuban Children's Program. The program established a precedent for a later federal collaboration between voluntary religious agencies and the government in providing for the care of successive waves of unaccompanied child migrants, especially after the 1980s. However, the Cuban Children's Program is also a great starting point for analyzing another and probably more important trend that has shaped the historical relationship between U.S. immigration policy and the migration experiences of unaccompanied children. Beginning in the 1960s and continuing today, media coverage of Operation Pedro Pan has consistently cast this experience as a humanitarian-motivated mission and focused on praising the government for opening its arms to Cuban children to provide care for them. It has consistently downplayed any political motives that might have underwritten the U.S. government's support for the Cuban Children's Program. However, the Cuban Children's Program actually provides one of the most dramatic examples of how, during the Cold War, U.S. immigration policy and foreign policy became closely linked to one another. This was particularly true in the case of refugees. So, contradicting our popular understanding of the United States as a haven for the poor and the oppressed, in fact, before the end of 1942, the U.S. didn't actually have a separate policy for refugee admissions. Instead, it expected people who were seeking asylum to qualify for entrance under the same terms as regular immigrants. So, qualifying for refugee status before World War II was actually an incredibly difficult process, and one that was only successful for a very small number of elite, usually wealthy, and often very well-known people. With the onset of the Cold War, this began to change as political leaders started to see the strategic value of admitting people who were fleeing from communist nations. Throughout the remainder of the century, refugee admissions policy would become highly selective and self-serving, as first Congress and then later the President, through a series of ad hoc executive actions, would repeatedly choose to grant refugee status to people who were fleeing leftist regimes while excluding people who were fleeing right-wing dictatorships. This has led to a historical pattern whereby people who were seeking to leave countries that we considered communist or for other reasons enemy nations have found it relatively easy to enter the U.S. with little expectation that they actually prove that as individuals they experienced a well-founded fear of persecution in their homeland. Whereas those who have attempted to flee brutally violent and repressive but non-communist dictatorships have regularly been denied asylum, despite their personal experiences of violence and terror, often state-administered. Any political basis for migration from right-wing dictatorships has often been dismissed, and people coming from those countries often summarily dismissed as supposedly economic migrants who were assumed to be motivated strictly by the opportunistic desire to improve their financial position in the U.S. So all of this historical background matters when we talk about U.S. immigration policy towards unaccompanied children, since much of that discussion hinges on which groups have been admitted to the U.S. and on what basis. The close relationship between U.S. foreign policy and our immigration policy, even after the end of the Cold War, has continued to play a key role in which children we have defined as refugees, as innocent victims of political persecution, and therefore deserving of humanitarian protection, versus those unaccompanied children that we have understood as illegal immigrants, opportunistic, dishonest, potentially criminal, who therefore needed to be punished and excluded. Following the Cuban Children's Program, the next federal government initiative dealing with unaccompanied children emerged in the late 1970s. Similarly linked to Cold War foreign policy goals, the 1979 Indo-Chinese Refugee Program would authorize the entry of thousands of separated and unaccompanied children from refugee camps in Southeast Asia and provide for their foster care in the United States after the end of the American War against the communist North Vietnamese regime. As it had during the years following the Cuban Revolution, the U.S. government again worked with voluntary religious agencies to provide foster care and services to thousands of Southeast Asian unaccompanied minors. This relationship between the U.S. government and voluntary religious agencies would be formalized the following year when the Refugee Act of 1980 created a mechanism for the admission and placement of unaccompanied minors and guaranteed federal funding for a new Catholic and Lutheran-administered unaccompanied refugee minor program. This program, which I'll refer to as the URM for the rest of this talk, remains the only state-funded social service agency that is authorized to provide federal foster care and assistance to unaccompanied minors. During the same year, so 1980, the Carter administration created the Cuban Haitian Entrant Program in response to the sudden arrival of more than 125,000 Cubans from the port of Mariel, as well as a sharp increase in the so-called boat people from Haiti during the 1970s and into the early 1980s. This legislation established that unaccompanied child migrants from Cuba and Haiti would also be eligible for refugee benefits. However, although the 1980 Refugee Act had in fact amended the nation's definition of refugee to include people fleeing political persecution from all nations, not just communist nations, in practice, U.S. immigration policy continued to discriminate in favor of those fleeing from leftist or communist regimes. As a result, during the first half of the 1980s, while the majority of the unaccompanied Cuban migrants children arriving with the Mariel boat lift were reunited with their U.S. relatives or placed in federally funded foster care, and within a few years were made eligible for an expedited path to citizenship, the majority of Haitian unaccompanied minors, like most Haitian adults seeking asylum, were placed in detention camps, including Camp Crome, which was a former missile base to the north of Miami. They were also threatened with deportation. This despite the fact that since 1957, Haiti had been subject to the corrupt and brutally repressive dictatorship of the Duvalier family, one of the worst human rights violators in the world. At the same time, the U.S. confronted a second immigration crisis. After the 1979 revolution that installed the leftist Sandinistas in power, Nicaraguans began fleeing their own war-torn nation for the U.S. Over the next 5 years, they were joined by several 100,000 Guatemalans and Salvadorans who were similarly escaping violent right-wing dictatorships in their own homelands. An estimated 70,000 anti-communist Nicaraguans sought refuge in Miami. Amongst them were more than 7,000 Nicaraguan minors who were fleeing the imminent conscription into the Sandinista army. Now, they were confident that they, like previous waves of Cuban exiles, would be granted asylum in the United States. In fact, less than 10% of their asylum petitions, even those of the minor children, were successful. And this at the same time that the INS continued to approve at much higher rates the asylum petitions of Iranians, Eastern Europeans, as well as to continue to provide visas and federally funded foster care for thousands of unaccompanied Southeast Asian children. These policies provoked an outcry from activists who accused Reagan of a racist and politically self-serving approach to asylum seekers. In fact, in June of 1982, the 11th District Circuit Court of Appeals ruled that Reagan's policies towards Haitian migrants were illegal, and in fact ordered the almost 1,800 Haitians who had been detained at Crome and elsewhere, including a number of children, to be released. However, in 1984, that decision was reversed, and the new ruling stated that illegal entrants enjoyed no constitutional protections and could thus be detained indefinitely. This 1982 decision would have important consequences for subsequent waves of undocumented entrants, especially the greater numbers of unaccompanied child migrants who would begin to arrive in the U.S. from Mexico and Central America in the 1990s. This ruling normalized the detention of undocumented immigrants in restricted holding facilities, in effect their incarceration, a practice which never before in U.S. history had been considered the first or usually the most appropriate way of dealing with unauthorized entrants or asylum seekers. Ironically, this harsh new approach to unaccompanied children, which emerged in tandem with a new rise in anti-immigrant sentiment, became the norm at exactly the same time that a new international consensus was beginning to emerge about the need for greater commitment to human rights for children. This greater concern for the well-being of children was enshrined in the United Nations Convention on the Rights of the Child, which became international law in 1990. Only 3 member states refused to ratify the Convention on the Rights of the Child: South Sudan, Somalia, and the United States. Since the 1990s then, while foreign policy continues to play an important role in shaping who is granted admission to the U.S. and who is excluded, an equally important contradiction has emerged between a growing concern for the human rights of children and the increase in anti-immigrant sentiment that demands that our government draw an ever sharper line between the treatment we offer those that we consider legitimate immigrants and those that we dismiss as illegal, regardless of whether or not they are children. Thus, since the 1990s, the U.S. government has taken great steps forward in its care of the small numbers of children that it designates refugees, and significant steps backwards in the treatment of the majority of unaccompanied children that it considers illegal immigrants. So, for example, between 2001 and 2003, the U.S. government passed legislation offering refugee status to former child combatants from Africa and provided resettlement to about 3,000 Sudanese lost boys and girls. In 2000, Congress also passed the Trafficking Victim Protection Act, which made child victims of human trafficking also eligible for admission to the U.S. and for federally funded care through the Unaccompanied Refugee Minor Program. In 2008, the Anti-Trafficking Act extended program benefits to certain special immigrant juveniles who were being held in federal custody. And an increasing number of unaccompanied children from Mexico, Guatemala, Honduras, and El Salvador entered the program at this time. In 2013, URM benefits were also extended to unaccompanied children who were admitted to the U.S. because they had been victims of certain crimes. However, the majority of the growing wave of Mexican and Central American children who have entered the U.S. since the new millennium, whether they're seeking reunion with their undocumented parents or safety from political violence and instability, forced recruitment into gangs, or desperate poverty, have not entered the U.S. with refugee status. Rather, they have arrived without legal authorization. So, for example, the average number of children caught by U.S. immigration authorities between 2004 and 2008 was close to 10,000 a year, a number which has risen slowly until 2014, when an unprecedented number, almost 50,000 children, were apprehended entering the United States. The largest number of these children are simply deported, most of them without benefit of an asylum hearing. The second largest group are detained, awaiting asylum hearings, often without access to adequate legal representation, and many of them in facilities which are patently unsuitable to children, without adequate access to nutritious food or water, outdoor spaces, appropriate educational facilities, privacy, in some cases, natural light. In many cases, although international human rights law stipulates that children should be reunited with their families whenever possible, in fact, U.S. Immigration and Customs Enforcement has often refused to release children to their legal relatives in the U.S. when they have suspected that their undocumented parents are also in the country. In these cases, children have sometimes been used as bait to locate those undocumented parents, and the entire family subsequently deported. Most of these recent asylum cases have decided against admitting unaccompanied Mexican and Central American children to the United States, despite the very real experiences of violence, terror, and abuse that many of these children have experienced. Instead, their claims for asylum are often met with suspicion and even hostility, and public perception, despite all evidence to the contrary, stubbornly insists on viewing the majority of these children as economically motivated and therefore as illegal immigrants instead of as refugees. So overall, while the U.S. government has made good progress in implementing some of the principles of the UN Convention on the Rights of the Child in its dealings with the small number of children that it actually considers refugees, it nonetheless continues to follow a highly inconsistent and politicized policy in determining which unaccompanied children will be considered refugees and which are to be considered economic and therefore illegal immigrants. And the treatment that is afforded to these two distinct groups of unaccompanied children is as different as the treatment received by the Cuban children welcomed into U.S. foster care in the 1960s and the treatment given to the Central American children held in detention facilities today. Despite the common sense expectation that all children are deserving of equal care and protection, regardless of their immigration status, our immigration policy has yet to consistently reflect accepted international norms for the treatment of unaccompanied child migrants. Nowhere is this more distressingly obvious than in the way our immigration system has dealt with the undocumented children who have arrived in the U.S. in the last year. So in conclusion, much more needs to be done to ensure that the treatment accorded to these most vulnerable would-be immigrants reflects Americans' belief in their nation as a historic haven for the oppressed of the world. So if you're interested in learning more about this topic, I have two books that I'd like to suggest to you. The first one is called Calculated Kindness: Refugees and America's Half-Open Door, 1945 to Present. And present in this case means about the mid-1980s. And a more recent book is Jacqueline Baba's Child Migration and Human Rights in a Global Age, which offers a really interesting comparison of the U.S. approach to unaccompanied children versus the way that European nations, which are increasingly dealing with their own unaccompanied crises of unaccompanied children. So I recommend both of these books, and I thank you for watching.